Hi, I'm attorney Julie Hauf. Today I want to talk about a couple items that we might not see all the time, but it's good to know how to deal with in a PIP setting. So I want to talk about transportation charges and over-the-counter drug charges. Now, first and foremost, we need to be aware of Section 5A of the PIP statute, which has a great line in there that says that a charge may not exceed the amount the person or institution customarily charges for like services or supplies. So if you are seeing a transportation charge or an over-the-counter drug charge, you first of all want to make sure that that provider is charging you as a PIP carrier the same way that they're charging any other patient that is paying with a different method. So getting into transportation, there are some HCPCS codes that you would probably typically see dealing with this. A0080, which is non-emergency transportation per mile when the vehicle is supplied by a volunteer, someone who has no vested interest. Then you have A0090, again, non-emergency transportation, and an individual with vested interest, and that's described as someone that's a family, the patient themselves, or a neighbor, someone that's got a connection and that knows the person. Then you've got A0100, non-emergency transportation, or a taxi. So for any of those, you want to note that the HCPCS book says that those particular charges are not something that's covered or valid under Medicare. The healthcare provider reimbursement manual for workers' comp also does not have any designation for those. So you want to look at some of the case law which says that transportation charges, when they're included in a demand letter, they need to list out the mileage. So it's pretty clear based on all of this that your transportation costs should not be a flat fee. They should be based on that mileage. And again, use that part of Section 5A of the PIP statute to go back and make sure they're charging you as the PIP carrier the same they're charging anyone else. For over-the-counter medication, this is an area that I've seen a lot of overcharging over the years, and we've got some good tools to deal with that as well, going right back to 5A, making sure everyone's getting charged the same thing. But then also the PIP statute itself, your policy may have language on how to deal with that. The PIP statute does not on its own talk about how that should be payable. However, the healthcare provider reimbursement manual for workers' comp does. And what does it say? It says that the provider's charge is to be paid or an amount not to exceed 20% of the actual cost of the drug furnished. And they go on to say that they're not allowed to pay for vitamins, nutrient preparations, or dietary supplements, which we don't usually see in PIP anyway. But so how is that important? What does that tell us? It means that we need an invoice in order to properly process that charge so that we can see what is the provider's cost, what was their cost of shipping and handling, and pay not more than 20% of that amount. Otherwise, we might look at someone coming back on an exhaust challenge and saying, well, you paid too much for this over-the-counter drug. Now there's some benefits left available for my client. So if the invoice was never sent and you didn't get it at the time, you denied this code, and then it's provided during litigation, is that a charge that you're now required to pay? Well, another very helpful section of the PIP statute, 4B3, for a denied charge that maybe some information wasn't included, it is going to be too late. So 4B3 talks about if a portion of a claim is rejected due to an error in the claim, the explanation of benefits or the explanation review is going to go back to the provider. When the provider gets that, or the person making the claim, they have, at their option, without waiving any other legal remedy for payment, they have 15 days to submit a revised claim, which shall be considered timely submission of written notice of the claim. So if you're in a situation where you think you should have had an invoice to pay the over-the-counter drug charge or any other charge, you needed that additional information to properly process that. Without getting that within 15 days of getting the EOR, so I would say, what is the date of the EOR, allow some time for mailing, and then look for something to be postmarked within 15 days of that. If that's not done, if you're provided those charges during litigation, you've got a great argument that it's too late, it's untimely, and it's not something that can be considered now. So go back, make sure that for any transportation and over-the-counter drug charges, they're charging you the same as everyone else, but then also look for these other specific facts too. Thanks very much. You know where to find us. Stay safe.